Hello and welcome to the first panel discussion of the second CFTJ annual conference. My name is Arameh Vartomian, and I have the true honor of moderating this very important, timely, and interesting panel discussion titled International Criminal Accountability Mechanisms, ICC, Paths to ICC for Non-Signatory States, and Ad Hoc Tribunals. As you might know, this is a very hot topic in Armenian legal field nowadays, whether or not Armenia should ratify ICC or not. And we have decided to do two panel discussions on this. This is the part one. Part two of the panel discussion will be this afternoon at 3:30. That will also be very interesting. I hope you can also attend to that one as well. Without further ado, I would like to introduce you to our very distinguished speakers. However, I will do this a little bit differently. I will introduce each speaker, and I will give them 15 minutes. And then once they are done, I'm going to introduce the next speaker. Our first speaker is Professor Gurgen Petrossian. He's a lecturer of international law at Friedrich-Alexander Erlangen-Nuremberg University, at the Catholic University of Eichstätt, Ingolstadt, right? I tried. He's also a consultant at one of the largest German textile companies on business and human rights in the framework of German Act, due diligence in supply chains. Previously, he was the head of International Criminal Research Unit at Friedrich-Alexander University, where he, with International Nuremberg Principles Academy, successfully led and completed research projects by German Foreign Office and German Research Foundation. His research focus lies in international law, international criminal law, and human rights. From 2016 to 2019, he was one of the main organizers of the Nuremberg Moot Court law competition. He was practicing as legal advisor to Armenia and Madagascar. Since 2019, he is the president of German Armenian Lawyers Association and a member of German Institute of Compliance. I should also note that Professor Petrossian is a very good friend of CFTJ and has been collaborating with us for the past year. And he has also taught lectures at the CFTJ's Law Clinic. With that, I will give you Professor Petrossian.
Ladies and gentlemen, I'm very honored to speak here before you on one of the important topics that, as it was mentioned, is a big hot topic today in legal field in Armenia. And I'm also very, very thankful for inviting me and also for organization of this very important conference by the CFTJ. And without much delay, I would like to start with my presentation on the joining the International Criminal Court, and especially to focus on some aspects that I think are relevant for today. Especially, I would like to speak a little bit about the public awareness in the International Criminal Court. Furthermore, I will go through the jurisdiction, what exactly is covered by the ICC jurisdiction, and of course, go through the opportunities, challenges, and risks that we may face in the future. And of course, at the end, I will conclude with some important summaries. So, starting with the public awareness, when I watch some media and see how the reactions about the ICC are, I see that there are still some misunderstandings how the International Criminal Court works, what exactly is expected by the International Criminal Court. And in order to do that, there are, for example, a lot of misinterpretation that that Armenia is going to bring a case against Azerbaijan, which is not true. This is not about the state responsibility. There will be no judgment against the Azerbaijan. And of course, the International Criminal Court as such will not solve the conflict itself. So what is important to note that the International Criminal Court is against one particular individual who commits international crimes. It calls for international criminal liability, and judgment is against the particular individual who committed international crimes. And of course, the person who is convicted is responsible for reparations. And in order not to have false expectations within our society, what exactly the court is about, it is important to make some trainings of the journalists, the lawyers, NGOs, investigative authorities, and of course politicians, in order not to have these false expectations from the ICC. Furthermore, I would like to, as it was mentioned, I am coming from Erlangen-Nuremberg University, and this is exactly the spot where the Nuremberg trials were held, and the outcome of the judgment of Nuremberg is of course the Nuremberg principles. I will not go now one by one explaining what the Nuremberg principles are about. However, I want to emphasize one and two of them especially. That any person who commits an act which constitutes a crime under international is responsible therefore and liable to punishment. So this means that independent of the fact where exactly international crime is committed, how and when, the person's fate is already decided. It's only about the modalities, how the person will be held in the future for responsible for the commission of the crime. And of course the internal law does not relieve the person from punishment. This is also important. Of course, the head of state, or also following the orders of the superior, does not relieve the person from the punishment. Of course, the establishment of the Nuremberg Charter was not an easy task, and I think this will be also not difficult. And of course, it is also difficult today with different international mechanisms that we are having. One of the core elements of the difficulty was the political, legal, and of course procedural. It was important to identify who exactly, which politician should be held responsible for the crimes, and what kind of crimes the person should be charged. And of course, from the procedural perspective, there are different procedural issues that we're facing from the civil law system and the common law system. But then, what is the same, which is the continuation of the Nuremberg tribunal after the Artsakh tribunals, is the ICC faces also a lot of difficulties. Like there are high expectations. There are of course a lot of political pressure on the ICC, and of course the same problems with the civil law and common law systems are also visible at the ICC. But then the question arises, why to join to the ICC? Well, Armenia has suffered numerous international crimes, and of course Armenians have suffered lots of international crimes. And individuals in Armenia need a legal protection from international crimes, and the way of this kind of legal protection is the membership of the ICC. And of course Armenia also needs to combat international crimes and of course support other societies who suffer from international crimes. Now I will turn to the jurisdictional issue. What is exactly is covered by the jurisdiction? Well, Armenian government intends to ratify the Rome Statute and of course recognize the jurisdiction of International Criminal Court starting from May 2021. What exactly does this mean? This means the following, that Armenia will become theoretically a full member of the ICC starting from the date of ratification. And of course, secondly, the ICC will have jurisdiction of the crimes committed since May 2021 on the territory of Republic of Armenia. Well, the territorial scope of Nagorno-Karabakh or Artsakh remains outside of jurisdiction. However, those international criminal lawyers, or also national criminal lawyers, are aware of different concepts of crimes, such as, for example, the completed crime, continuing crimes, and of course the composite crimes. But I will not go explaining now every concept to you, but I would like to emphasize especially the continuing crime, what exactly the continuing crime is about. This is a violation of a primary obligation targeting a potentially ongoing situation that has been committed and then maintained. Well, we have huge jurisprudence coming from the European Court of Human Rights, and mostly referring to the state responsibility, that the continuing violations, that the human rights may be also continuing. We have, for example, huge jurisprudence from European Court of Human Rights, independent to the fact when exactly the state joins one particular statute. If the human rights violation is still continuing and the state doesn't do anything in order to stop the violation, then the state may be held responsible for that. Let's turn to the International Criminal Court. Well, here it is important to emphasize especially the terminology or definition of deportation. Well, let's have the following scenario, that civilian population was deported under Article 7.1d of the Rome Statute from the state not party to the state to another state not party to the statute, and which becomes later party to the state. So let's see what the deportation is about. This means a forced displacement of the person, consent by expulsion or other coercive act from the area in which they are lawfully present, without grounds permitted under international law, Article 72D, Rome Statute. Well, we have in jurisprudence of the ICC the situation in Bangladesh and Myanmar, and in that particular case, the Rohingya population was deported from Myanmar to Bangladesh. And in particular, in deciding on the jurisdictional issue, the International Criminal Court decided that inherently transboundary nature of the crime of deportation contains the Article 12, 2A of the statute. An element of the crime of deportation is a forced displacement across international borders, which means that the conduct related this crime necessarily takes place on the territories of at least two states. Another type of international of continuing crime is the persecution. Well, again, according to this scenario, the persecution is bound to particular grounds, such as racial, national, ethnic, cultural, and religious, and of course other grounds. And also, again, in the same case, the International Criminal Court found that if it were established to the applicable threshold that members of the Rohingya people were deported from Myanmar to Bangladesh on any of the grounds enumerated in Article 71H of the statute, the court might also have jurisdiction pursuant to Article 12.2a of the statute over the crime against humanity of persecution, considering that an element or parts of the crime, for example the cross-border transfer, takes place on the territory of a state party. This would mean, in the following scenario, that the crime of deportation does not end with only the crossing the borders. It has a lasting effect and ends only when the deported person has access to his or her homeland. And in this particular scenario, the conclusion would be that this would mean that the temporal gap mentioned in the scenario is also covered. Theoretically, the ICC may have jurisdiction over victims of the crime of deportation in the context of Nagorno-Karabakh conflict in relation to the 44 Days War. Let's speak about the opportunities, what exactly the victims of deportation may do. The ICC is one of the revolutionary institutions which allows the victims to have an access to the proceedings. They are participants of the proceedings, and accordingly they may have the right to bring evidence, to testify, and also or to express their views and concerns when their interests are met. And what exactly is important to note is that the NGOs representing the victims of deportation, they need to understand how the International Criminal Court works and how the institutions are working with each other. Especially, it is important that the NGO representations representing the victims have a contact point with the victims' participation in reparation section, and of course to understand how the office of the prosecutor is working and what kind of evidence the prosecutor will need for the future cases. Another challenge, a big challenge of the ICC is of course that it takes time. The length of proceedings is bound to different factors, like the investigation takes very long time, because of various reasons, witnesses or evidence that would need to be found and translated, for example, because of the language issues, the evidence, prioritization of the cases, and of course the legal and procedural difficulties that are present at the ICC proceedings. So in this particular case, it's of course a challenge, and the NGOs and victims should have passions right the International Criminal Court proceedings. Another big issue is, of course, the risks that may also be present while joining the ICC. Well, we see that after the decision on the after the decision of the Constitutional Court, there was some attempts on the media expressing especially that there are some political pressure on Armenia not to join the International Criminal Court. However, I truly believe that the joining the ICC is not only a legal cooperation in the criminal matters, but it is also legal protection for the individuals living in the Republic of Armenia. And of course, it is the decision of the Republic of Armenia to be a sovereign state to decide fruitfully, meaningfully, to join the the international community against international impunity. At the end of my speech, I would also like to emphasize some important points. That, first of all, the Nuremberg Principle 1, which says that every person is responsible for international crimes, is not only applicable for the ICC. There are other alternative ways how we can bring the international criminals before justice. This could be the mechanism of universal jurisdiction. This could be another ad hoc mechanism, or I don't know, hybrid mechanism, where the international accountability for international crimes may be done. And of course, the ICC, for example, it brings a huge opportunity for the victims communities to speak out before international court or international criminal court, and of course have chances to present their views and concerns. Thank you very much for your attention, and I will now give the floor to the next panelist or the moderator. Thank you very much.
Thank you very much for this very interesting conversation. I think it's really important for some of us to understand exactly what ICC does and how it works. I have to acknowledge, I didn't know, I thought we could have brought cases to ICC, state versus state, just up until 2 months ago. So this is very important for us to, get an understanding of how it works, what are the challenges and opportunities for Armenia, for example, to join the ICC. Now, I would like to do a few logistical things. I forgot to mention that you can submit Q&A or questions, and our volunteers will be picking up, and I will be asking the questions in the Q&A period at the very end. With that, I would like to introduce you to our next speaker, Ms. Yuzuki Nagakoshi. She's a program officer for Institute for Legal Support and Technical Assistance in Laos, People's Democratic Republic. In Laos, she's in charge of training programs for judges and prosecutors, as well as an advocate for legal reform. She's originally from Japan and is a licensed attorney in the state of New York. She'll be speaking of the possible impact of ICC's involvement in the Nagorno-Karabakh conflict. With that, please. Thank you.
Good morning, everyone. Thank you very much for being here, and I also thank the organizers for this great invitation. And I look forward to learning more about this conflict. My background is in international criminal law, but I am still learning about Nagorno-Karabakh, and I am delighted to be here for these 3 days for this great opportunity. So today I would like to speak about the possible impact of the ICC's initial involvement. I would like to focus on arrest warrants in the conflict. And I come with a background in international criminal law, especially at the Country Analysis Unit at the International Criminal Court. I was there for a while, analyzing mostly the situation in Myanmar. So I was very glad to have the first presentation about that, because then I can skip the part about that. It was already a great presentation. Go to the next one. Yes. So I'd like to look into 2 situation countries, namely Sudan and Uganda, which are cases in which ICC involvement and arrest warrants had an impact on situations on the ground. And as a matter of principle, joining the ICC to push for accountability, impunity, all these things are very important, but they often have real life consequences, and one has to sometimes balance between what might happen in terms of humanitarian situations, especially on the ground, and pursuing justice and accountability. And I'm not necessarily a proponent of this simplified view of peace versus accountability. I think they can go hand in hand, but the timing of how things should develop is really critical. And since a lot of people are just connected to Armenia through the Latin corridor, I think this topic is very pertinent to the situation in situation before us. So now talk about Sudan. It's an old case. It's nevertheless very pertinent. Mr. al-Bashir was a president of Sudan, and he is still at large. After the things that have been happening in Sudan, there were rumors that he actually escaped captivity, but I've heard that he has not. He's still in a hospital controlled by the army. And he was accused of genocide, war crimes, and crimes against humanity in Darfur. And at the time the arrest warrants were issued in 2009 and 2010, he was the president of Sudan. So this was an arrest warrant against an active head of state. So what happened after the arrest warrant was issued was, in terms of diplomatic consequences, nothing, because al-Bashir went to many, many countries around the world, and they all refused to extradite. And the African Union also was heavily involved in non-cooperation with the ICC, and this has become one of the cases that triggered the angered response of African countries concerning the ICC. And there has been a lot of cases brought to the ICC about non-cooperation by South Africa, which triggered some discussions within South Africa whether they should leave the ICC. So it's been a very contentious situation there. And yes, so if something similar happens to the case that we are discussing today, would there be any consequences on people who have an arrest warrant hanging over them? It's a little bit questionable, but yes. And this is the worst thing that happened from the ICC involvement. And the head of the WFP at that time, the World Food Program, was a Japanese person, and to this day, he has just been hating the ICC for this thing, because they got WFP kicked out, and there was a real humanitarian suffering in Darfur. And basically what they did was that they cut off and they expelled international organizations from Darfur, and many vital supplies to Darfur were delivered through the WFP and all these related NGOs and the Red Cross and all these situations. And the expelled organizations fed 1.1 million people and provided medical care to 1.5 million people, and they were cut access. And this is the main reason why I'm coming and speaking here. This is a similar situation, although I might say that Darfur is a little bit better situation because it is not landlocked by non-friendly forces. So, and the arrest warrants, it could be said, this is not a quintessential example of this. I'll discuss about the other situation later. The arrest warrants may impede the peace process or transitioning into a civilian government. And al-Bashir has always been very interested in how the cases unfold. And there was a political unrest and a coup d'etat that in Sudan in 2018 and up to 2019 that tried to help restore civilian governance in the country. But this has actually been hampered by the military. And one of the reasons, I doubt, it's probably not the main reason, but some speculate that the Sudanese transitional government's agreement with the ICC to extradite al-Bashir was one of the reasons for the coup. Because before that, when he was the head of state, it didn't really matter whether the ICC had an arrest warrant against him, because he can decide whether or not to extradite himself, and he will never do that, so that was fine. But so it does not necessarily apply to the current the status quo. But if an arrest warrant is against the head of state, usually they will cling to power. They will not let go of the power, and that hampers peace negotiations or civilian transitions, especially because ICC prosecutors have been very reluctant to give de facto amnesty for good reasons. So the next situation does not concern a head of state. This is a very sympathetic case, actually. So he was, Mr. Dominic Ongwen, was a high-ranking commander of the Lord Resistance Army, a Ugandan rebel group. And this has been a very long conflict, and he was recruited as a child soldier. So by the time he reached the age, he became of age, he was already in the culture. He killed many people. So that was kind of, it's a very, sympathetic case where the victim turned to become a horrible perpetrator. And he eventually surrendered himself to, the circumstances are kind of disputed, but to the American forces, and he was sentenced to 20 years in prison in 2021. So this is a case where the arrest warrants actually impeded the peace process significantly, or that is the way that it has been discussed in this context. The prosecutor at that time, Mr. Ocampo, has mismanaged the situation according to some scholars and practitioners. But basically, the Ugandan government enacted the Amnesty Act so that people can come out of the jungle and they can reunite with their families and start a life, because it was just simply too much to arrest and punish everyone who got involved in Lord Resistance Army. And Uganda needed these people to kind of move back and just start building a constructive life. And the Ugandan government asked the ICC, so they initially asked the ICC to investigate the case, but then subsequently, the president, Museveni, went back and said, hey, actually, I think these arrest warrants are impeding the peace process, so we want to have this canceled. And Mr. Ocampo, the prosecutor, said, no, we don't want to do that because it happened. And so there was a situation where most people were given amnesty, but people with an ICC warrant over them were not. And reportedly, in fear of arrest and extradition, the leader of the Lord Resistance Army, the rebel group to which Mr. Ocampo belonged, refused to appear and sign the peace agreement. So the peace agreement was not signed. I mean, there de facto, there is peace, de facto peace, but there was never an official agreement that was signed because the preceding things were discussed without Kony, who was the LRA president. But ICC arrest warrants contributed to cutting Sudan's support for war criminals, and I think this was also mentioned in the earlier presentation that he would attract attention, and basically an ICC arrest warrant against a high-level official would mean that this person is engaged in wrongdoing. So that kind of condemnation from the international community could be a huge contribution to anyone who wants peace and who wants to end impunity. So yes, I will not go through this slide because we all know about this. So what would the possible impact be on the Nagorno-Karabakh conflict if the ICC actively starts engaging in the conflict? So one possible result is national prosecution of individuals. To avoid the ICC's investigation and prosecution affecting Azerbaijan and Armenia, but Armenia for that matter, Armenia must conduct a genuine investigation into all alleged war crimes and other violations of the Rome Statute, and also the same could be said of Azerbaijan, because the ICC has been very, very keen on looking impartial, because they always receive numerous criticisms about which people they have chosen to prosecute. So if a case is opened, they will investigate everything regarding Armenia and Azerbaijan so that they will not be criticized later on for decades and decades on. And Azerbaijan is also free to accept the ICC's jurisdiction over crimes committed in Azerbaijan, and then this will kind of open the Pandora's box. But then, if there is a genuine investigation on both sides, that could lead to peace, that could lead to accountability. So this is one positive outcome that does not follow directly from the ICC, but from the consequences, so in order to get complementarity. And I think the largest concern here is the access to Nagorno-Karabakh by Armenian supplies and international peace forces. And an ICC warrant could result in international attention to the conflict and increased support, but especially because Russia is a peacekeeper in the region. And if Armenia ratifies the Rome Statute and the relationship between the Russian peacekeepers become negative, then this is a real problem. If Russia can't keep the peace and Armenia is upset, and if the Latin corridor is shut, what happens? So this has happened in Sudan, and this might happen here. So although accountability is very important, it is my passion, we cannot have people actually suffering so much because we want accountability. So that is a realistic concern. Yes. And if some arrest warrants are issued against war criminals, fugitives might not face a real risk of prosecution. If they are Azeri high-ranking state officials, they will not extradite themselves, right? So the realistic circumstances are limited, especially if they want to travel to China, to Russia, to the US. These are countries that, well, the US is a little bit of a separate issue, but they usually do not cooperate with the ICC. So to what extent this would actually impede diplomatic efforts is slightly questionable. But the good thing is that because peace talks will not be influenced significantly, because they don't have to seek amnesty necessarily, because they will be granted de facto amnesty in the country to which they belong to. So the impact on peace talks probably would not be too much. And so there is one last thing that I would like to shortly mention. It's the Article 98 agreements. Why am I discussing this? It's just because so I was thinking how Armenia could join the ICC without losing Russia's support. And one way to do this is through an Article 98 agreement, which is something that the US has been using, because Article 98 of the Rome Statute allows arguably allows non-extradition of nationals, non-extradition of non-nationals. So if Mr. Putin comes to Armenia, to Yerevan, if preceding his visit, if there is an agreement between Russia and Armenia saying that we will not extradite anybody to the ICC, then it arguably gives Armenia a way out of this conundrum between having to extradite Mr. Putin and having to join and wanting to join the ICC. So that is a partial solution to the problems that I've mentioned. And now I see that my time is up. So if you would like to discuss more about any of these aspects, I'm here for 3 days. We have a Q&A session. So thank you very much for listening. I hope this adds to this benefit.
Thank you very much for this very interesting presentation. I think ICC's involvement and perhaps its impediment to the peace process is something very interesting to consider while we are talking about the ratification of the Rome Statute in Armenia. So thank you for that. Please keep the questions coming. I have a very explosive question that I will ask. You will see, I promise. It's very good. But please keep them coming. So the next presenters, because there are two of them, will be speaking about Armenia's potential case before the ICC. And each one will be getting 10 minutes. So the first one would be Anoush Bagdassarian, who is a very dear friend of mine. She's a visiting professional at the International Criminal Court and a Harvard International Legal Studies Fellow. She received her J.D. from Harvard Law School. She's a co-founder of Rerouted Archives, documenting over 250 testimonies from Syrian and Armenian refugees who have fled Syria in the last 12 years. Anoush is also a founding member of CFTJ and is the published author of the historical fiction play at the Armenian genocide entitled Found, which has been presented at book events around the world and produced for stage productions in New York and California. She has so much more that I can talk about, but I'm just gonna keep it to that. Along with Anoush, Mischa, Gurgen Hall, who is the modern political violence research and writing specialist at the University of California, Los Angeles, will be speaking. Mischa is a legal researcher and intern for the Center for Truth and Justice, as well as the Rerouted Archive. He additionally is an incoming editor-in-chief for the UCLA's undergraduate law journal. She's a student member of, or he's a student member of American branch of International Law Association's Committee on International Criminal Court. He's also a fellow at the Royal Society of Arts, and he's a very good student with a very bright future. With that, I will give you the floor, Anoush.
Okay, good morning, everyone. Can you hear me okay? Yes. Okay. It's an honor to be on this panel. My name is Anoush Bagdassarian, and as Arameh mentioned, I'm a lawyer currently working at the International Criminal Court, and as such, I must say that the views expressed here are my own and do not reflect those of the court. I'm presenting today in my capacity with the Rerouted Archive, which is the NGO I created 6 years ago to work on cultural preservation and justice issues for the global Armenian community, and I'm joined by one of our stellar interns, Mischa Gurgen Hall, and today we'll be presenting something that we hope you will find useful and will inspire action. Fact-finding for any case is never done by just one person. It takes a team, and we invite all of you here in this audience, all of you watching online, to be a part of this team. Many of you already are, and for those of you who aren't, you're here now, so you are. You received papers this morning that we hope can serve as a non-comprehensive practical guide on how to assist if you are an NGO documenting information like CFTJ, if you are a journalist, if you write blog pieces, if you, a lot of different ways that we'll talk about. And we know this presentation will shed further light on that goal. So, for the past few months, we have been working on a report outlining Armenia's potential case before the ICC. As Armenia considers ratifying the Rome Statute, which we've heard about wonderfully from the past two speakers, Rerouted has turned its attention to assessing the strength of different potential charges at the court in light of evidence that is already publicly available. If Armenia goes forward with ratifying the statute, it will be allowed to, as Dr. Petrossian explained, refer the case to the ICC itself, or with the 12.3 declaration, other countries can refer the case. So at that stage, the ICC's Office of the Prosecutor, OTP for short, will open a preliminary examination into the situation and will use open source information, as well as information that's sent to it, to map offenses and assess the criteria to be able to move the case into the next phase, investigations. So to make this assessment, the OTP uses news sources, NGO reports, and other publicly available information to inform its work. Thus, we have identified some of the information that would be helpful to be publicly reported on, or privately gathered and sent to the OTP for certain potential charges in the Rome Statute. We've identified these as gaps on our slides because they are things that were gaps for us in our open source research. It's very possible and very likely that the people in this room or others working on this conflict have already collected this information and have it within their private archives. And due to the sensitivity of some of the information, we are not suggesting that it all be made public. Rather, we hope to identify the gaps in public information so that actors in this space can recognize two main things. First, if you have this information, you should consider that it makes its way to the ICC if and when Armenia ratifies the statute. And second, if you are in a position to further document this information publicly, for instance, if you are a journalist or an NGO, it could be beneficial to do so. But it's important to note that such reporting should be done as summaries, and not with a level of specificity that could create inconsistencies later, or potentially fatigue and re-traumatize witnesses. You can read the OTP's practice guide for civil society, that picture here, for more best practices. So we will now go through some of the different offenses we have identified as having potential to be charged in a future prosecution. This list is of those crimes that will not be mentioned in our presentation. This is not an exhaustive list, and there are a lot of offenses on here that would be stretches to achieve and would take creative lawyering, but that doesn't mean that they could not be done. We unfortunately won't have time to go through many of the interesting questions that arise when assessing these crimes in the Armenian context, nor will we have time to address the satisfaction of chapeau elements for war crimes and crimes against humanity, but our subsequent report aims to do that, and we hope to release that this year, so keep an eye out for that. And it'll also review questions of admissibility, guiding precedent in its application to this case, potential charges starting from May 10, 2021, and also potential charges starting from September 2020, and the challenges we might run into with each charge. So keep an eye out for that, and in the meantime, let's return our focus to the presentation of today. And this is to re-emphasize that this presentation is with the aim of shedding light on areas that could benefit from further public and independent documentation. We'll briefly review some gaps that we found in available evidence that, if identified and documented by all of you, could help make a stronger case before the ICC. So let's start with the war crimes related to attacks. The three war crimes that we've chosen to highlight here are attacking civilian objects, attacking protected objects, and attacking undefended places. In international humanitarian law, it is prohibited to attack, destroy, or render useless objects that are indispensable to the survival of the civilian population. Certainly, this applies to the attacks on civilian infrastructures in Salsk and Jarmuk and other places from September 2022, and it seems that this could also be extended to apply to the most recent bridge that was rendered unusable by Azerbaijan at the border with Armenia, Nagorno, and Artsakh. For war crimes, one of the most important things to establish is whether the attack can be deemed a military necessity, and if so, whether the harm suffered was proportionate to the advantage gained. In the context of attacks on civilian, protected, or undefended objects, most often the perpetrators defend the damage done as the unfortunate collateral damage of a real military necessity. And the way this collateral damage claim is often measured is by looking at the distance from the military target to the collateral damage, identifying which weapons were used, and assessing whether the affected areas are within the radius of allowable error typical for these harms. On my last independent fact-finding mission here to Armenia with Harvard, Yale, and University Network for Human Rights, we learned, for example, that in one of the towns where civilian objects were targeted, there was a military base about 1 kilometer away from the site of damage, but the weapons used only had about a 100-meter radius of error. So that kind of information is extremely useful when verified for determining that the war crimes on this slide occurred and were not merely the result of collateral damage. Thus, for gaps, helpful additional information to be either publicly reported on or at least sent to the court in private submissions would include at least the following 3 things. First, maps of attacks and military positions, including distances if disclosable. Second, what type of military equipment was used and their margin of error. And third, statistics or lists of homes and other protected objects that were affected, harmed, and destroyed. Oftentimes, Human Rights Watch and other NGOs will report on this and verify the attacks, and more reporting like that. Mnemonic does this, it would be really helpful. So moving on to the crimes of murder, willful killing, and mutilation. This one will be relatively short because the definitions and elements of the crimes are fairly understandable. So for the crime of against humanity of murder and the war crimes of willful killing and mutilation, we know about the executions on Armenian soil from 2022, as well as at least 1 mutilation. But having independent sources write more about these and anything else that might have taken place on Armenian soil since May 2021 would be helpful, as well as further information about general command structure in Azerbaijan and specific command makeup or orders for these particular crimes. So moving on now to deportation, I'll hand it over to Mischa.
I'd like to, first of all, thank Dr. Petrossian for giving us a little overview of the crime of deportation, and in particular, the ICC's Article 15 decision in Bangladesh, Myanmar, which is very relevant and helpful to our present discussion. So deportation and forceful transfer are codified as crimes against humanity, but have very similar elements to corresponding war crimes of forceful transfer and unlawful transfer. As its name suggests, this crime exists in 2 manifestations: deportation, which consists of the forceful displacement of individuals across state boundaries, and forceful transfer, which consists of internal displacement within the boundaries of an existing state. In this case, we believe we have 2. Again, Dr. Petrossian touched on the Bangladesh-Myanmar precedent very well, and discussed how the territoriality of the crime of deportation is dependent on the crime's existence in two states, whereby both the state from which an individual was deported from and the state which they were deported to consists of the territorial basis of the crime, meaning that upon Armenia's ratification of the Rome Statute, the ICC will have jurisdiction over the deportation of Armenian civilians from Artsakh into the Republic of Armenia. This is very unique in the context of the crimes both within our presentation and those outside of it, as it represents one of the very few offenses in which the ICC will have territorial jurisdiction over acts occurring in Nagorno-Karabakh, or Artsakh to use the proper terminology. So with this in mind, some evidence must be bolstered, and that's where you in the room come in, and those of you listening online. As the ICC has emphasized, a key aspect of the offenses of deportation and forceful transfer are victims' responses to specific coercive acts. In this regard, the work of CFTJ and other fact-finding organizations and NGOs is crucial, as gathering victim testimonies is the core underlying element of proven victim response to coercive acts. However, the key element must be remembered, and that is the nexus between Azerbaijani attacks and a physically or psychologically coercive environment that has resulted in, to quote the ICC jurisprudence, quote, genuine lack of choice on the part of individuals transferred. This means that we must establish causal links between specific Azerbaijani attacks and specific victims' displacement. Thus far, NGO and civil society reporting of displacement has taken on a holistic lens, but we must move beyond this and adopt a greater specificity in understanding what civilians were displaced from where and what specific Azerbaijani acts occasioned that displacement. Thus far, as I mentioned before, this holistic approach has led to generalities, has led to us understanding deportation, forceful transfer as a general consequence of an overall situation. We must move beyond this and make explicit and emphasize these causal nexuses within the evidentiary record. Secondly, further documentation of internal displacement is necessary, as international organizations do not document internal displacement with as much vigor as they do transborder displacement of persons. So, in order for this area of evidence to be bolstered, like I mentioned before, we need greater specificity in reporting. We need greater specificity in, for example, an Armenian civilian who was forced to flee their village. Why were they forced to flee their village? The general Azerbaijani attack on the Republic of Armenia is insufficient to prove this causal nexus. We need, for example, what civilian was forced to flee from what town because of what artillery bombardment, mortar attack on their specific town. That is how we can fill the gaps, the evidentiary gaps for deportation and forceful transfer. I'd like to now transition to the dual crimes of persecution and apartheid. Again, Dr. Petrossian referenced the crime of persecution, and it becomes increasingly relevant when we're viewing the ethnic context of the Artsakh conflict. The core elements of persecution lie in some violation of fundamental human rights through underlying acts perpetrated with discriminatory intent on the basis of political, racial, ethnic, national, religious, or gender identity, whether true or perceived. That's a bit of a mouthful granted, but a great variety of fundamental human rights have been recognized as potentially amounting to the crime of persecution, including the violations of the rights to life, liberty, and security, the right to not be subjected to torture, and the right to property. As for the required underlying acts, all that is required is that they amount to the gravity of other crimes against humanity or other crimes within the Rome Statute, meaning that all of the crimes discussed and listed in this presentation can all satisfy the requirement of What this also means is that with persecution, we can also get jurisdiction over Nagorno-Karabakh, as the crime of deportation can serve as an underlying act to the crime of persecution. The most important element of persecution, discrimination against an identifiable group or collectivity on prohibited grounds, is the most challenging for us in this room, for NGOs, to provide evidence for. This is because, while discriminatory intent can be inferred from contextual factors, including hateful public rhetoric, such inferences can often be difficult to substantiate. Accordingly, we need more in terms of Azerbaijani government sources. Establishing discriminatory intent will depend on a large part in our ability to pinpoint official documents, orders, memoranda, and the like, which reveal official policies of discrimination against Armenians on the basis of their ethnic and national origin. Moreover, while many of us here can likely refer anecdotally to the vitriol-laced social media posts of Azerbaijani officials disparaging Armenians, inciting racial hatred, we thus far have lacked a concerted effort to create a centralized repository of such posts and public statements. These can serve as powerful testaments to discriminatory intent, but only when they're available in a centralized, easy-to-access manner that can be easily, efficiently marshaled into evidence as to evidence this greater existence of discriminatory intent. Briefly now to turn to the crime of apartheid, which is a crime that there is essentially no prior jurisprudence on, which makes us trailblazers in this regard. In order for the crime of persecution to amount to apartheid, it is necessary to prove that persecution, this crime that we've been discussing, was institutionalized and systematic in nature, thus demanding more primary government sources, as was previously mentioned, but also a more thorough understanding of the Azerbaijani legal system and how ethnic discrimination against Armenians on the basis of their national ethnic origin becomes institutionalized through actual laws, through the letter of the law, and how the letter of the law is applied. Thus, a more formal understanding of the Azerbaijani legal system will be a core aspect in proving this institutionalized apartheid against ethnic Armenians in Artsakh. With that, I would like to thank you all for your time and turn it back to Anoush.
Thank you, Mischa. Okay, one more crime, and then we will wrap up. There's too much. There's such creative potential case. Okay, so drawing on what Mischa has just said about persecution and apartheid is a closely related discussion of incitement to genocide. Direct and public incitement to genocide entails, quote, publicly creating a state of mind in an audience that would induce its members to commit genocidal acts, unquote. So essentially it entails creating an atmosphere that is conducive to the later commission of criminal acts inspired by hatred. So speeches, broadcasts, or publications are all valid forms of incitement due to its public component in intending to destroy in whole or in part a national, ethnical, racial, or religious group. Incitement to genocide is not a substantive offense, it's an inchoate offense. So inchoate offenses are just incomplete offenses like attempt, conspiracy, solicitation, and those are criminalized even if the substantive offense doesn't materialize. So for example, in most criminal justice systems, an attempt to commit murder is criminalized even if the murder is unsuccessful. The same is true at the ICC with regard to incitement to genocide. Inciting genocide is a crime even if genocide doesn't occur. While international tribunals have not yet brought an incitement to genocide charge against a defendant in a context that did not ultimately end with a genocide, that doesn't mean that they cannot. Relevant and guiding case law for this crime most recently comes from the ICTR, the International Criminal Tribunal for Rwanda, though it was first seen in the trials for the Holocaust perpetrators post-World War II. These convictions have historically been for those who controlled some aspect of the media, whether it be a leading magazine in Nazi Germany or the newspaper and radio in Rwanda. In the case of Armenia, we can use hate speech that is old, even that which occurred outside the temporal scope of the court's jurisdiction, i.e. before the war, as long as the crime that it led to occurred within the scope of the temporal jurisdiction over the case. But we have to be careful about distinguishing incitement from hate propaganda, as all hate speech is not necessarily incitement. In Nahiman et al., the tribunal distinguished incitement from hate propaganda, explaining that broadcasts, such as the one alleging that Tutsis, quote, are the ones who have all the money, unquote, did not constitute direct incitement, as it did not, quote, call on listeners to take action of any kind, unquote. But that does not mean that language that satisfies this charge must contain an explicit call to action. To help us reconcile this need for direct incitement but no need for explicit call to action, here's some language from a previous case law on this point. Quote, however, even when a speech contains no explicit appeal to commit genocide, it may still constitute direct incitement to commit genocide in a particular context, so long as the speech is not considered ambiguous within that context. In order to determine the speech's true meaning, it may be helpful to examine how it was understood by the intended audience, unquote. Thus, in order to bolster such a charge for a possible future indictment for this crime, we need you to continue reporting on and assessing the following. 1, public statements by Azerbaijani officials, and 2, the public response to and understanding of such statements. Lastly, there is a third area that requires more attention, and while we don't have time to discuss it today, I will just mention it here, which is that we need to show intent to destroy in whole or in part a national, ethnic, or racial group for this crime to be successful. Now, to wrap up, we will close with, if the slide moves. Well, if the tech can change the next slide, that would be great, but if not, no worries. Well, we'll close with general gaps. So each of the crimes mentioned has their own unique potential, with some requiring more creative arguments than others, as do many other potential charges we haven't discussed or named at all. This presentation was not meant to be exhaustive, and we hope that you take it as a starting point for thought, discussion, and action. To summarize, here are some of the general gaps that would have been on the slide, but I'll tell you them, and please remember them, that we hope you will address through further independent reporting across the board. So 1, more documentation of all the gaps areas discussed above that you have on your papers. 2, maps of military positions, if disclosable. 3, or sent privately. 3, verified documentary evidence, such as photos, videos, and social media activity. 4, identification and information about perpetrators and links to specific crimes. 5, the command structure in Azerbaijan. 6, this hate speech database that Mischa spoke about. And lastly, first-hand non-circumstantial evidence of intent. There's certainly more, but again, this is a starting point. So thank you all for listening. Thank you to the recruited interns, Tali, Mischa, Halut, Shant, Asfik, and Caroline, who have been working on this upcoming report we have about this. And for the future of Armenia, we all need to work together across generations and mentor as much as we can. And just as I've had mentors in this room and mentored others in this room, I urge us all to continue doing so in our own way. And a huge thank you to CFTJ for the important and necessary work they do. And lastly, a thank you to all of you, the audience, for the work you're already doing and will continue to do post this conference to help fill these gaps. If you have any additional questions or would like to discuss anything further, the email is on the bottom of the paper that you all have. Thank you so much.
So far, just to summarize, we have spoken about joining the International Criminal Court. We have also spoken about the possible impact of ICC to the peace process. And lastly, we heard about Armenia's potential case before the ICC. We heard about some examples and some recommendations that what we should look out for. Now, last but not least, I would like to introduce you to our very own CFTJ Law Clinic Fellow, Khachik Zaqaryan. He's a law student at Yerevan State University. He was a conscript during the July 2020 attack against Armenia in the Davush region. He's also a veteran of the 44-day war in Artsakh. Khachik is a recipient of Medal of Service from the President of Artsakh in February of this year. Thank you for that, Khachik. Yes. As I mentioned, he's a law student. His interest particularly lies in area of civil law. He hopes to become a judge one day. I'm sure that will happen. So with that, Khachik will be speaking about his own work, collecting testimonials for CFTJ. And with that, I'll give it the floor, Khachik.
Hi everyone. I'm very glad to see you all here for our second annual conference. I want to speak some about missing in action. It is common knowledge that during military combats, some people get missing in the actions. Some troops are acting. It's common that enemy troops in the enemy state act in accordance with the orders by the enemy state. In our case, the Republic of Azerbaijan acted as the enemy state. The Azerbaijan has been denying the fact that our servicemen and civilians went missing due to war which was unleashed by Azerbaijan toward Artsakh on 27 September 2020. Some human rights violations by Azerbaijan have been gathered by the Center for Trust and Justice, and I will share some of them with you today. But to protect the confidentiality of our witnesses, they will not be identified. The first one is about the witness's husband who went missing due to war during 27 September 2020. He got a call about and informed about the war. After that, he joined the military unit, which was situated in Armenia, Kapan. The last contact was on 20 October 2020 at 10 p.m., which was about 10 minutes. He got a contact with his family and informed that he would be he and other Armenian soldiers would be transferred to Mevri military post from 2 to 5 days. After that, he will return to home. But after that, the witness and other family members never got a call and information about him, and they were extremely worried. After that, they informed ICRS, the government, but no one confirmed the possible POW status of that man. But then they informed that he has a possible status POW because they have witnessed some videos, two very important videos on Telegram and Facebook channels. She saw that he was kidnapped with hands in the back, and the second video shows about being pushed by the Azeri soldier. She could easily identify the Azeri soldiers by their military uniforms of other flag, which was displayed on their chest. By the way, she could easily identify her husband by physical appearance, by his face, by his clothes, and also from his shoulder straps, identifying he's a senior sergeant. After that, after not confirming the POW status, he is missing to date. The videos were uploaded firstly on the Facebook and Telegram on 28 November 2020. After the second time that was uploaded on 6 December, a channel Telegram called Colored 18. The second case is about also witness's husband has been missing due to the war unleashed by Azerbaijan on 27 September 2020 towards Artsakh. And after that, not having any information or some confirmation about the location of her husband, she got extremely worried. After that, she met some friends of her husband, but no one have a correct information about his location. But after that, she learned from others that the 3 buses transferring them and another 62 Armenian soldiers was stopped and blockaded by Turks. 2 buses had stayed to fight, but the third one had left. All started by the time they stopped to have a smoke break, and that time some group approached to them shouting that they are Armenians in Armenia. After that, the commander had figured out that they are not Armenian, but in fact they are Azeris. The shouting had stopped. After that, some time later, on December 15, 2020, she had received some video from Facebook. She learned from the Facebook video about 13 Armenian captured soldiers who were surrounded by the Azerbaijani soldiers, and they were on their knees. After that, a time later, she got some information from Armenian from Germany. She got him from the social network, and he said that he has currently POW status in Azerbaijan Baku prison, and he had a right shoulder injury. but he is missing to date. And for conclusion, I want to say some strokes from convention that all the family members have the right to know what happens to their beloved ones. Governments and enemy state authorities have the obligation to provide some information about that, to bring their family members closure, to reunite the families. All this is supported in the International Convention for protection for all people from enforced disappearance. Thank you very much.
Thank you so much, Khachik. We just heard about several testimonials from victims of war crimes that can perhaps be used for a potential case at the ICC. I must mention, while CFTJ has been doing lots of wonderful work, its main concern when we started was to actually put together evidences like this that Khachik just mentioned. We have over 300, well over 300. There you go. We have 450 testimonials of similar testimonials from victims of war crime, repatriated POWs, their families, and so on. So thank you, CFTJ, for your work. Now we have come to the Q&A session. I promised you a very explosive question. I don't know if I should ask it now or I should keep it. I think I'll ask it now. So one of our audience has asked, does Armenia have to arrest the president of the Russian Federation? I should say, should Armenia arrest the president of the Russian Federation if Armenia ratifies the ICC statute? Now, I ask this because scholars have been talking about this for the past several weeks. Some say yes, some say no, and I would like to hear what you think, and yeah, I'll get to that. It's open, and whoever can take it. It seems like Professor Petrossian has a... Yeah.
I have a very negative approach about it, and about discussion about the arresting of Putin, because the joining of the ICC, from Armenian side, does not, it doesn't have to be a discussion in Armenia of arresting of Vladimir Putin or not to arresting Vladimir Putin. Because, you know, some politicians have several times made some kind of statements which are very dangerous for the Armenian interests. And while we keep discussing this issue, it makes more and more challenging for us. You know, after this kind of statements in the media, there was a kind of chaos that everybody was imagining how the barracks or the police officer will run before the cortege of Vladimir Putin and try to shoot on the tires to arrest the guy. Yeah? But this is not like that. We need to be more concentrated on the aspects that why the Republic of Armenia wants to join the ICC. That's why I'm a bit. I have a very negative approach about this whole discussions on Vladimir Putin.
Thank you for that, Ms. Yeah, please.
So, so my answer depends on whose side I am on. I am an attorney, so, but as a normative matter, there's a difference between joining the ICC and also accepting the ICC's jurisdiction for the Nagorno-Karabakh conflict. And since Armenia is ratifying the Rome Statute, meaning that it will accept its jurisdiction, it is a member of the Rome Statute, I think it would be imperative for Armenia to arrest Vladimir Putin if he comes to Armenia. There's one way to avoid that. It's the Article 98 agreement that I've already discussed. It is questionable whether that kind of de facto reservation is legal, but it has been done mostly by the United States, and I don't think that it is so unethical to suggest that here, but I think that is one possibility, so that Armenia is not so openly violating the Rome Statute The other way, obviously, is to accept the jurisdiction only over the crimes that has been discussed today, and then that will not obligate Armenia to arrest Mr. Putin. And another thing, so that is my normative, my legal answer is if you join the Rome Statute, yes, there is an obligation. And there have been some discussions about that, but I think the law is relatively clear on that. And concerning the heads of state, immunity discussion, especially because the case that we discussed about Sudan, that was a case where the Security Council has referred the case to the ICC, whereas this is not such a case. Obviously, Russia is a member of the Security Council, so there is a way to discuss, there is a way to argue that because it is not a Security Council referral, the head of state immunity somehow has bearing in the overall discussion. So Armenia does not have to arrest Mr. Putin. It's a possible way to think about it. I do not subscribe to that theory, but in terms of realistically whether Armenia should arrest Mr. Putin, I think you have a better understanding of the situation way more than I do. But considering that there is a peacekeeping mission in Nagorno-Karabakh, and that is a vital support to this conflict, there is always a question whether this normative approach should take precedence over protecting civilians, and I think the answer is no. So that is the should Armenia do that for Armenia's interest, and whether Armenia is obligated under international law. It's two separate issues, and I have separate answers for each of these questions. So.
Thank you. Anoush, do you want to chime in? No. Okay, sounds good. So we heard Khachik talking about the testimonial evidences that he had collected. This is directed to Mr. Petrossian, but Anoush, because you talked about some potential cases, you can also talk about this. The questioner asks, how can CFTJ's testimonial that CFTJ has collected be helpful to the case, the potential case that Armenia might want to bring? From Mr. Petrossian, from Anoush, or whoever wants to chime in.
Dr. Petrossian, if you want to add anything, of course, go ahead. But I think ultimately, first of all those gaps on that page, of course, they're non-exhaustive, but CFTJ, in their continued testimonial collection, can continue to ask, for example, what Mischa had said when he mentioned forced displacement. We need to have, it can't just be, oh, I was displaced from Artsakh or displaced from my home in Armenia because of general Azeri attacks. We should actually understand, was your town harmed? Was your home harmed? And CFTJ does that already, but to continue filling in specific gaps that we found in the open source evidence, that would be really helpful.
First of all, and then second of all, if and when Armenia does ratify the Rome Statute, CFTJ and other organizations can submit their own Article 15 submissions to the court with their testimonies and with all the evidence they have. I know different human rights clinics do this, different NGOs do this, and if that process goes forward, I know we're all watching eagerly at the Constitutional Court, now at the Parliament, what will happen. But CFTJ can absolutely use the testimonies for that, and a lot of times NGOs that are non-Armenian want to collaborate with and work with Armenian organizations and civil society organizations on the ground to have a better sense of what's happening, to have a better sense of the landscape and the atmosphere, etc. And so CFTJ can also, which they already are doing, ensure that they work with other organizations that come in that can maybe are more common to submit Article 15 submissions or have a bigger name or something like that in the non-Armenian sphere, to ensure that the testimony that they're collecting that are so important make its way to the potential case or the gaps that we've identified make its way to being reported on by more and more organizations in a broad summary-like way, so that we're not creating inconsistencies to bolster the potential case and charges. Yeah.
Maybe the only thing that I would like to mention and add to that point that this kind of observations and submissions, that of course they need to be very carefully coordinated within the other victims groups or other NGOs, because here we need a very tight cooperation between all kind of institutions working for the one particular goal, in order not to let at the future stage some kind of misunderstanding or I don't know, any kind of misinterpretation of different things. That's why I truly believe that that the coordination also on the state level with the NGOs should be there.
Thank you, Mr. Petrossian. There is another question for you, directed to you, but again, it's open to Ms. Nagakoshi and Anoush as well. And the questioner asks, oh, I just lost the question, found it. Does circumstantial evidence in the form of environmental damages, psychological torture, and or inaccessibility to food constitute grounds for the forced displacement clause?
Mischa, you go for it, but in addition to forced displacement, those things, Mischa and I, and Mischa, you can touch on it, we were discussing last night, they also could potentially fall into other inhumane acts. So we can discuss that more independently, individually, but to answer the forced displacement, Mischa can take that one.
Yes, Mischa.
Yeah, definitely. Forced displacement, as kind of was mentioned before, is the core aspect of it is that there was a genuine lack of choice on the part of the individuals who were transferred. So establishing that genuine lack of choice can take a variety of forms, and a lot of these contextual, more circumstantial factors can play a key role in establishing that victims had no other choice but to flee. These are things that we could show as proof that there was a significantly coercive environment in place at the time of their displacement. All of those factors you had mentioned would be key to building that. Something Anoush had mentioned on other inhumane acts, which is another crime against humanity under Article 7 of the Rome Statute. It's a very kind of catch-all residual crime against humanity, basically encompassing anything that rises to the gravity of the other listed crimes against humanity, but is not explicitly listed. So it's in there as basically a flexible crime to incorporate basically crimes that the drafters of the Rome Statute of the Rome Conference hadn't thought of. And in the Bangladesh-Myanmar case, an argument that the prosecutor put forward was this concept of a right to return, a right of forcibly displaced individuals to return to their homes from the territory from which they were displaced. The prosecutor, this is the previous prosecutor, argued that this would constitute, or the denial of a right to return would constitute other inhumane acts. In the pretrial chambers Article 15 decision, they specifically sidestepped the issue, finding that it was not necessary to determine whether that constitutes an Article another inhumane act for the purpose of the statute, because that was just a jurisdictional decision, and they established jurisdiction using the kind of trans-border element of deportation. But I think all of those circumstantial aspects can be really key, both to proving the coercive nature of displacement and to potentially substantiating this new area, this quite exciting area of kind of like trailblazing lawyering, that is the right to return in the context of other inhumane acts.
Mr. Petrossian, yeah, you were.
I can just add, I think the answer was very sufficient, but I would like also to add, for the public who doesn't is not very much familiar with the international criminal law, for example, we don't deal with any kind of deportation, not every part of deportation. So we need to speak about in international criminal law two types of concepts. One is the contextual elements, like for example the chapeau elements that we have in international criminal law, which for example in case of crimes against humanity is the widespread or systematic attack against the civilian population. And this is what makes international criminal law differ from the national criminal law, that the deportation must be fallen under these contextual elements. Just for the public who is not aware about the international criminal law, and these elements are were not, I think, weren't really touched from none of that, and just this importance that these all elements are obvious in particularly in Artsakh case.
Thank you for that. Now I have another question that unfortunately I can't really read, but it's very the question is very. The questioner has put their names. It's very helpful. And I would like to ask Mohammed Ibrahim if you would like to stand up and ask your question in person. Yeah, I just can't read some parts of it, so please.
You can speak. Thank you so much, Bana. Thank you so much. It's discussed. I have a question, so I make use of this a lot of information about. I'm from Somaliland. My name is Mohammed Ibrahim. So my question is direct to Anoush. I think if I write a pronunciation that night. Sorry for that. My question also, I'm from Somaliland. I have a lot of cases of genocide that takes place in the 1980 to the 1991 by the Siad regime. So a lot of genocides have been, but cannot be, I think, prosecuted as preparators. So I think more than 32 years cannot be prosecuted, cannot be recorded, I think. So at that time, this genocide has a limited time that cannot be prosecuted or sued for the preparators, regime and his regimes. It needs a time, or it is not. It's not to have a limited time. If that question you have answered, let me explain that question I need. So maybe I make use of that questions. I recorded it. Thank you so much.
Thank you. Let me just tell about, you can say, but Mohammed and his friends are from Somaliland, as you mentioned, and they are here to be trained by CFTJ and learn how to document war crime evidence, just the way we have done in the past several years. So thank you for being here, guys. Now, you want to, Anoush, you want to, yeah, okay. Anoush, yeah, is directing question to Mischa.
No, I'll pass it on to Mischa. He can answer it very articulately.
Firstly, thank you for your question. Thank you so much for being here. In regards to genocide, like the other offenses, like all the offenses under the Rome Statute, there's a temporal limit on jurisdiction. And the way this would work is when an individual state ratifies the Rome Statute, by default the court's jurisdiction can only start upon the date of ratification. So for Armenia's case, let's say if we were to ratify the Rome Statute in 2023, by default only crimes after the date of ratification would fall under the statute. The way countries have got around this is by filing an Article 12.3 declaration, which can extend the court's jurisdiction retroactively, kind of at the request of the state. The caveat with this is that it could only be extended up to the point that the Rome Statute entered into force, which is in 2002. So in theory, that is the absolute limit of how far back the court's jurisdiction can stretch. That's in 2002. The way kind of this has been gotten around in the past is through ad hoc tribunals, through hybrid tribunals. For example, the extraordinary chambers in the courts of Cambodia were making decisions up until a few years ago. I believe it's still technically active, so they're existing contemporaneously as the ICC, but the crimes under its jurisdiction far predate the entry into force of the Rome Statute. So that would any jurisdiction over pre-2002 crimes would have to be through some alternative international criminal tribunal or accountability mechanism.
Yeah, so I just want to perfect answer. I just want to add that just because the ICC might not be able to take it doesn't mean there can't be another institution, another tribunal created, another mechanism for justice. The ICC is not the only option, A. And B, I really like this idea of creative lawyering, but I don't know how far it can go. But maybe maybe the continued harms that the people, the Somaliland people, are experiencing can fall under the jurisdiction of one of these crimes as being experienced in the present. And so it's a stretch maybe, but it's another possibility if you want to try to take advantage of the ICC jurisdiction. But I think also the ICC shouldn't be seen as the be-all, end-all of accountability measures, because there's so many other, honestly at times, better for the community justice efforts than ICC. But happy to talk to you more about the ICC at any point throughout the conference.
Yes, please. We are a little bit short on time. If you can be like 30 seconds, because we have more questions.
Sure. Yeah. So I thought it was a really interesting question, and just to follow up on Anoush's comment, since the ICC only prosecutes individuals, it might be a better use of resources to establish genocide. For example, you can go to the ICJ, although the statehood of Somaliland could be an obstacle, and then there is the African Court on Human People's Rights, where you can also file individual complaints. I don't think Somaliland has made accepted the African Court's jurisdiction for individual cases, but these are all like alternative ways to get things sorted out. And because it has been in the past, I mean, apart from the continuing violations aspect, if it is more your purpose to establish that genocide had occurred and need a systematic approach, systematic solution to the pain and suffering, the ICC might not even be a good forum. And there's another small aspect that I would like to add, sorry about that, is that you can also, because there's no temporal limit to your claims, you can also file cases, for example, in Argentina. Yes, that has been, the Rohingya has done that, and I'm sure that Daniel would have a lot to add in his presentation. So you can go to many different countries in the world and find a suitable forum for your claim, and then file a case there, because there is no temporal limit in domestic courts. And that might be a better use of your time. They might render decisions quickly, and you can rely on the domestic systems. So that was the short answer.
Thank you so much. We have, let's say, 4 more minutes. I have a lot of questions left, but I will try to ask a few of them. So one of the questioner asks, and this is directed to the second speaker, Ms. Nagakoshi, and it says, how does ICC, but again, it's open to everyone, how does ICC deal with the fact that Azerbaijan will not allow any NGOs to Artsakh or Nagorno-Karabakh, and how would an ICC, for example, accomplish an investigation like this with the fact that the host country will not allow it?
So this has been the case for many international criminal cases. Usually, because it has state backing, kind of cases, so usually the state that backed the crimes, they will not allow any investigations. Like, for example, in Yugoslavia, the Serbian government, as I understand, has not cooperated with the proceedings in Yugoslavia, but in that case they had an overarching, the UN, NATO, and the United States pushed for things to happen, and it did happen. But when there is no occupying force, or where there is no international oversight, that is very difficult. But it has been done. For example, there has been the independent fact-finding mission on Myanmar, and the Myanmar government has not been has never been cooperative, but they have they've been to refugee camps in Bangladesh, and if there is a state that gives sufficient backing and gives sufficient place to open up a country office, for example, and support, I think Armenia would be a good country for that, for obvious reasons. It is very difficult when the country does not cooperate, but such is not an exceptional case for Nagorno-Karabakh. So as long as there are sufficient states to cooperate and to house refugees and get their testimonies. And there are a lot of advanced technique employed by, for example, Amnesty, Human Rights Watch. They do a lot of surveillance from outer space even. They have access to all these modern technology to establish widespread attacks against the civilian population. So it is difficult, but it is actually not impossible for the ICC or any international mechanisms to investigate.
Thank you. One more question. There are a lot more left, but I will ask this one. It says, the questioner asks, why does Armenia need to ratify the Rome Statute? Why not just apply through the ad hoc way? This way, perhaps Armenia can avoid being, prosecuted in ICC.
Well, I believe that Armenia, because of its history, because of international crimes, it suffered too much. And I think it should be part of these like-minded states that believe in this ideology of fighting against international impunity. And I think that being also a member to the Assembly of State Parties will give also the possibility for Armenia to modify, also to take part in the development of the International Criminal Court. But mostly, this has also symbolic and also political reasons why Armenia should be the full member of the ICC, rather just doing it separately or at all.
Also, which Dr. Petrossian said, but deterrence, I know maybe a lot of people don't believe in deterrence as a real thing, but I think if Armenia can at least try to put up another obstacle for Azerbaijan to commit these crimes by saying, okay, if you continue doing this, you now might be prosecuted by the ICC, it could help prevent future crimes. So if the benefits outweigh the costs in that regard, if that's the kind of analysis we're making, then I think deterrence should be a heavy factor that we weigh.
Sorry, just to add one last,
very quick, please.
One very quick thing. If Armenia were to accept the jurisdiction of the court through an ad hoc declaration, it would need another country to refer it to the prosecutor. While if it were to accept, it were to become a full state party to the Rome Statute, then it could refer itself, which would be significantly easier. In the previous case, we'd have to basically appeal to a friendly country, France, some other country, to refer us to the statute, which creates an entire other kind of diplomatic endeavor that we have to engage with.
Thank you so much. I have more questions, and I'm so sorry I couldn't ask some of very good questions that are here with me. Very interesting topic, very timely, stellar panelists, great conversation. As you can see, no question is off limit here. You can ask whatever you want. And thank you so much with that. We are exactly on time again. Thank you. There is going to be a part 2 to this conversation at 3:30. Please don't miss that one. And we have another panel coming up right now. Thank you.